classification would be permissible only if there is a reservation for a subclass as well as a larger class. That the finding of M. Nagaraj, Jargal Singh and Devinder Singh to the effect that creamy layer principle is also applicable to scheduled castes and scheduled tribes lays down the correct position of law. That the criteria for exclusion of the creamy layer from the scheduled caste and scheduled tribe for the purpose of affirmative action would be different from the criteria as applicable to the other backward classes. Before I part with my judgment, I place on record my deep appreciation for the valuable assistance rendered by the learned counsels appreciation.
Obliged to Lordship.
My opinion is the most lengthy, as it incorporates the exhaustive and well-considered opinions of Honorable the Chief Justice and Brother Justice Goy. However, I have made the conclusions and the opinion shortest. May I read it? I am generally in agreement with the reasons and conclusions arrived at in the opinions of Honorable the Chief Justice and Brother Justice Goy. In particular, that the holding in E.V. Chennaiya that subclassification within scheduled caste was impermissible, does not lay down good law, and stands overruled. Further, any exercise involving subclassification by the state must be supported by empirical data. I am also in agreement with the opinion of Brother Justice Gawai that creamy layer principle is also applicable to scheduled castes and scheduled tribes, and that the criteria for exclusion of creamy layer for the purpose of affirmative action would be different from the criteria as applicable to the other backward classes.
Obliged to Lordship. Justice Sharma.
So, unanimity and consensus in the opinions expressed by the larger benches on the constitutional matters are desirable for the sake of certainty and strength of the law laid down. I, for one, believe that the dissent for well chosen reasons would be equally important for an effective adjudication in a democratic functioning of judiciary, which would have a potential to develop the law in future. So I respectfully disagree with the opinions expressed by my esteemed brothers. At the outset, I have not approved the manner in which the three-judge bench had referred the matter to the larger bench without assigning any reason. So I have said that it may be noted that Andhra Pradesh Scheduled Caste Rationalization of Reservation Act 2000 has already been declared unconstitutional by the five-judge bench in E.V. Chennaiya as well as in 2005. Similarly, Section 4.5 of the Punjab Scheduled Caste and Backward Classes Act 2006 has also been declared unconstitutional by the division bench of the High Court of Punjab and Haryana, while the judgment dated 29th March 2010, in respect of which present reference is made. Hence, both these acts, as on the date, have been declared unconstitutional. It is further required to be noted that E.V. Chennaiya decided in 2005 was holding the field for about 15 years till five-judge bench in Devinder Singh on the reference made by the three-judge bench further referred the matter to the seven-judge bench in 2020. It is noteworthy that three-judge bench had referred the matters to the larger bench without assigning any reason, much less cogent reason as to why it could not agree with the decision in E.V. Chennaiya delivered by the Constitution bench. The law was settled by the Constitution bench and was prevalent since 15 years was sought to be doubted and unsettled by the three-judge bench by passing a very cryptic and perfunctory order not supported by any reason as quoted herein above. The importance of doctrine of binding precedent in the administration of our judicial system hardly needs to be reiterated. The doctrines of precedents and practices are the core values of our legal system. In series of cases, the constitutional benches of this court have time and again emphasized that when a decision is rendered by this court, it acquires a reliance interest and society organizes itself based on such legal order. When substantial judicial time and resources are spent on the references by the constitution benches The same should not be further referred to the larger bench by a smaller bench in a casual and cavalier manner and without recording reasons for disagreement. In the instant case, the reference was made by the three-judge bench to the larger bench for revisitation of the earlier decision of Constitutional Bench in Ivichenia without assigning any reason and in a very casual and cavalier manner, and that too after 15 years of its attaining finality. When a law was settled by the previous bench in Ivichenia, after considering the previous judgments, including Indra Swani, and after investing substantial judicial time and resources, and when the same had held the field for substantially long period of 15 years, in my opinion, the very reference by the three-judge bench to the larger bench for reconsideration of the decision in Ivichenia, that too without assigning any reason, was inappropriate and not in consonance with the well-settled doctrines of precedent and stare decisions. Having said that, I have dealt with the constitutional interpretation. It is quite well settled that in interpreting any law, including the Constitution, the text of the provision under Constitution under consideration would be the primary source for discerning the meanings that inhere in the enactment. Sometimes, as a matter of constitutional necessity, it may be prudent to widen the search for the true meaning, purport, and ambit of the provision under consideration. However, one has to bear in mind that no provision, no word, or expression in the Constitution exists in isolation. They are necessarily related to transforming and in turn being transformed by the other provisions, words, and phrases in the Constitution. Even if a dynamic interpretation is necessary and necessary and the meaning necessary to fit in the same circumstance is found in the text itself, it would be always better to tread a path as close as possible to the text by gathering the plain ordinary meaning to see whether that meaning is validated by the constitutional values and the scheme. While giving a broad and generous construction to the constitutional provisions, the rule of plain meaning or literal interpretation, which remains the primary rule, has to be kept in mind. As transferring from the, I quoted the Constituent Assembly debates. As transferring from the Constituent Assembly debates quoted here in above, the object of inserting Article 341 was to eliminate the necessity of burdening the Constitution with long list of scheduled castes and scheduled tribes. It was proposed that the President, in consultation with the governor or ruler of the state, should have the power to issue general notification in the Gazette specifying all castes and tribes or groups thereof deemed to be scheduled castes and scheduled tribes for the purpose of the privileges which have been defined for them in the Constitution. The only limitation put was that once a notification has been issued by the President, any elimination from or any addition in the list must be made by the Parliament and not by the President. In the words of Dr. Ambedkar, I quote, "The object is to eliminate any kind of political factors having a play in the matter of disturbance in the schedule so published by the President." On the legal provision of Article 341, I have said, from the aforestated legal position, there is no room of doubt that the presidential list, as notified under Article 341, assumes finality on the publication of the notification, and that the caste, races, or tribes, or part of or groups within caste, races, or tribes specified in the notification are for the purposes of Constitution deemed to be the scheduled caste in relation to that state or union territory as the case may be. It is only the Parliament by law which can include in or exclude from the list of scheduled castes specified in the notification notified in clause 1 any caste, race, or tribe or part thereof, or group within any caste, race, or tribe. Such notification notified under clause 1 cannot be varied even by the President by issuing any subsequent notification. Scheduled castes are not a caste within the ordinary meaning of caste. It is by virtue of notification of a President under Article 341 that the scheduled castes come into being. Though the members of the scheduled castes are drawn from different castes, races, and tribes, they attain a new special status by virtue of the presidential notification. A bad reading of Article 341 brings out the quintessential concept that scheduled caste is an amalgam of castes, races, groups, tribes, communities, or part thereof, and is a homogeneous group, and that once notified by the presidential list, they acquire special status of scheduled caste, which cannot be varied except by the parliament by law. On the state's competence to enact the law, I have said that though the executive power of the state government is coextensive legislative power of the state legislature, none of the entries, either in list 2 or list 3 of the 7th schedule, confers any legislative power upon the state to rationalize the reservation by subclassifying or subdividing the caste enumerated in presidential list prepared under Article 341, as was sought to be done by the state of Andhra Pradesh, nor does it confer any power to provide or reserve the quota for a particular caste or caste from amongst the scheduled castes enumerated in the presidential list prepared under Article 341 of the Constitution, as was sought to be done by the state of Punjab and Haryana. In absence of any executive or legislative powers, the states are not competent to divide, subdivide, subclassify, regroup the castes, races, or tribes from amongst the scheduled castes, nor could it give any preferential treatment by reserving a quota for a particular caste, race, tribe out of the quota reserved for the entire scheduled caste. So subclassification or subdivision of caste amongst the scheduled caste by the state for the purpose of reservation per se may not amount to inclusion or exclusion of any caste from the presidential list of scheduled castes. It would certainly amount to tinkering with or varying the notification notified under clause 1, which is clearly prohibited under clause 2. When all castes, races, or tribes enumerated in the presidential list are deemed to be the scheduled caste for the purposes of constitution, any preference given to or any quota reserved for a particular caste or race or tribe out of the quota reserved for the entire class of the scheduled caste for the government jobs by the state would certainly deprive the other members of the scheduled caste from having the benefit of reservation to the extent the quota is reserved for such particular caste or caste. Any such action on the part of the state would not only tantamount to discrimination in reverse and violation of Article 14, but would also tantamount to tinkering with the Article 341 of the Constitution. Article 15(4) is an enabling provision which enables the state to make special provision for the advancement of any socially or educationally backward classes of citizens or for the scheduled caste and scheduled tribes, and clause 5 thereof enables the state to make special provision for them in respect of admission to educational institutions. Similarly, Article 16(4) enables the state to make any provision for reservation of appointments or posts care of any backward class of citizen, which in the opinion of the state is not adequately represented in the services under the state. These provisions under Article 15 and 16 are merely enabling provisions and could not be treated as a source of power to legislate the law for subdividing or reclassifying or subclassifying or regrouping the caste, races, or tribes enumerated as scheduled caste, which have acquired special status by virtue of Article 341 of the Constitution. On the affirmative action, I said, under the guise of providing reservation or under the pretext of taking affirmation action for the weaker of the weakest section of the society, the state cannot vary presidential list and tinker with Article 341. Such power, if exercised by the state in absence of any executive or legislative power, would be colorable exercise of powers. It hardly needs to be reiterated that the idea conveyed by the doctrine of colorable exercise is that although apparently a legislature in passing a statute purports to act within the limits of its powers, yet in substance and in reality, it transgresses its powers, and transgression being veiled by what appears on proper examination to be merely a pretense or disguise. As well settled, the whole doctrine of colorable exercise is based on the maxim, you cannot do indirectly what you cannot do directly. Any action of the state in the name of affirmative action, if not permitted by the Constitution, could not be validated or vindicated by the courts by molding or tinkering with the specific provisions of the Constitution. in view of the above, I am of the opinion, I've discussed Indra Sahani and Nagaraj and Janil Singh, and then I've said, I'm of the opinion that Indra Sahani had sought to define backward class in terms of social backwardness while considering the ambit of backward class for the purpose of Article 16.4. It did not deal with the issue for the scheduled caste or scheduled tribes, particularly in the light of Article 341 or 342. Rather, it categorically kept the scheduled caste and scheduled tribes outside the purview of consideration. The scheduled caste being the most backward class amongst the backward classes and having acquired special status by virtue of Article 341. The question of defining backward class scheduled caste did not arise and rightly not dealt with in Indra Sahani for the purposes of Article 16.4 of the Constitution. The affirmative action of the states have to be within the constitutional framework, and if they are not, the courts cannot ratify the same by bending or molding the specific mandates contained in the Constitution. Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier by ignoring constitutional provision dealing with the subject and thereby achieve something indirectly which cannot be achieved directly. The action of the state, though well-intentioned and affirmative in nature, if violates the specific provisions of the Constitution, cannot be validated by the Supreme Court in exercise of its jurisdiction under Article 142. The removal of inequalities or remedy to remove inequalities cannot be permitted at the cost of violation of the specific provision of the Constitution. When the wordings of the provision of the statute, in the instant case, Article 341 of the Constitution, are clear, as also the intention of the draftsman of the Constitution, the court cannot add or subtract the words from such provision to give it a meaning which the court feels would achieve the goal of social transformation. Sometimes the affirmative action and the Constitution intersect with each other in complex ways, as affirmative action policies are framed by the states to promote diversity and to address historical inequalities, while the legal frameworks have to ensure that these policies are implemented within the bounds of the Constitution. The implementation of the affirmative action policies must align with the constitutional and legal principles, particularly those related to equality and non-discrimination. In short, the affirmative action and the legal frameworks, though both aim at more equitable society, they must navigate complex legal principles to ensure fairness and constitutionality. I am therefore of the opinion that the law laid down by the five-judge bench in Ivicinea is correct and deserves to be confirmed.
I have divided my opinion into 7 parts, starting with introduction, amendment to the constitutions vis-a-vis the reservation with reference to the case laws, central government and state government's commission on scheduled caste, scheduled tribes and OBCs, ramifications of reservation, casteless society, caste system vis-a-vis the bond system. Reservation is only a medium of facility and its execution revives caste. And then conclusion, which I agreeing with the scholarly separate opinions authored by the Chief Justice and Brother Justice Gavai, I summarize my views as under. The policy of reservation as enshrined under the Constitution and by its various amendments require a fresh relook and evolvement of other methods for helping and uplifting the depressed class or the downtrodden or the persons belonging to scheduled caste, scheduled tribe, and other backward classes communities. So long as no new method is evolved or adopted, the system of reservation as prevailing may continue to occupy the field with power to permit subclassification of a class, particularly scheduled caste. In the constitutional regime, there is no caste system and the country has moved into a casteless society. Except for the deeming provision under the Constitution for the limited purpose of affording reservation to the depressed class of persons downtrodden or belonging to SC, ST, and therefore any facility or privilege for the promotion of the above category of persons has to be on a totally different criteria other than the caste, maybe on economic or financial factors, status of living, vocation, and the facilities available to each one of them based upon their place of living, urban or rural. The reservation, if any, has to be limited only for the first generation or one generation. And if any generation in the family has taken advantage of the reservation and have achieved higher status, the benefit of reservation would not logically be available to the second generation. It is reiterated that periodical exercise has to be undertaken to exclude class of persons who, after taking advantage of reservation, has come to march shoulder to shoulder with the general category. The reference is accordingly answered, and it is held that subclassification of scheduled caste is permissible in law for the purposes of reservation.
Justice Sharma.
Privilege of reading the lucid and Dr. Justice D.Y. Chanchu, Chief Justice of India, and Honorable Mr. Justice B.R. Gavai, respectively. I am fully in agreement with both opinions to the extent that the validity of subclassification within scheduled caste has been held to be constitutionally permissible. Moreover, I am fully in agreement with the opinions to the extent that any exercise involving subclassification by the state must be supported by empirical data that ought to underscore the more disadvantaged status of the subgroup to which such preferential treatment is sought to be provided vis-a-vis the constitutional class as a whole. However, on the question of applicability of creamy layer principle to the scheduled castes and scheduled tribes, I find myself in agreement with the view expressed by Justice Gavai, that is, for full realization of the substantive equality inter se, the scheduled caste and scheduled tribes, the identification of the creamy layer qua scheduled caste and scheduled tribes ought to become a constitutional imperative for the state.
Grateful to Lord.